but at the same time, my understanding is you don't think this is going to be upheld on appeal. Why is that?
Courts have difficulty being too counter-majoritarian. And as you noted at the outset, this is one of the most politically popular provisions, that felons just don't have a political constituency that advocates them having guns. And this is one thing both sides can agree on. And I think courts will find it difficult to cut that far against popular opinion. One of my early Second Amendment articles, I kind of looked at what courts, especially state courts, had historically done here. And what I found was that courts often declared unconstitutional laws that were extreme or went beyond what the popular mainstream was at the time, but that they didn't go ahead and radically rewrite a whole bunch of state laws. And so when you had states early on prohibiting the carrying of concealed weapons, they said fine. When you had one or two states like Georgia in the early days say, well, we're going to ban all public carry, they said, no, that's too far. But they also accommodated the desire for regulation. There was an early case in Kentucky called Bliss versus Commonwealth that said the Second Amendment was absolute and not capable of any restriction. And that was uniformly repudiated by the other courts and eventually by Kentucky through constitutional convention. So I think courts, just as a matter of kind of legal realism, courts strike down laws that are particularly extreme, but they generally don't go against the mainstream opinion in this way. And I think this is not the only one. There are other laws. I was doing a debate, and Darrell Miller, who's at Duke, brought up that, no matter how they interpret the Second Amendment, they're not going to authorize people to carry weapons aboard commercial aircraft. And that's, another example where finding an analog is virtually impossible. You could most certainly have a gun in your carriage or, is subject to the common law crime of going armed to the terror of the people. But, to say that a particular mode of transportation was out, I don't think will happen. I think the other thing that's interesting about the felon in possession, the indictment ban, is that it doesn't also reach the concurrent and supplementary power of courts to put reasonable conditions on bail. So even if this were struck down, I think the judge would still have power as a condition of bail to say, well, you're not going to possess a firearm or don't go out and buy a firearm. I have trouble imagining that, if Osama bin Laden had been captured and transported back to the United States, well, I guess he wouldn't have been allowed on bail. But, if somebody who's very dangerous would have been allowed on bail, they're going to say, well, unlimited power to buy guns until the jury verdict comes in. I don't think it's going to happen. And I think it's a mistake to say that every regulation has to have a historical analog. I think, Justice Thomas in his majority said this is not a regulatory straitjacket. You have to analogize a little bit. And I think, there was going to have to be some adaptation to new circumstances and to new types of laws. And I think you're seeing some of the growing pains here. Now, one last thing, the good side of the growing pains is that by causing a division of opinion in the courts, you may see more attention from the Supreme Court. One of the things the Supreme Court does as its core mission is to keep federal law uniform. And so as circuits split on issues, they will step in. They had not stepped in the Second Amendment space for a long time because no court ever struck down a law on Second Amendment grounds. And then you had the DC Circuit do so in Heller when Heller was in the Court of Appeals, and then they got involved. Then there was a circuit split and they had to get involved. So the fact that there may be differing opinions may give the Second Amendment more attention from the federal courts.
Yeah, certainly. And I'd expect there to be a lot of differing opinions on a lot of these issues from here on out because they're dealing with an entirely new standard of review. And that's sort of what Judge Counts' point. He repeated a number of times talking about, known unknowns and unknown unknowns and, trying to work his way through this case with the just historical analog as his guide. And, he didn't seem to like that. I'll be honest. There's a number of comments in his ruling about, for instance, the difference between disarming somebody in the 18th century versus the 21st century, where he argued at least that firearm ownership at that time was much more vital to basic survival than it is today, was one of his arguments for why, there might not have been the same sort of exact historical copies of these types of laws, because disarming somebody completely at that time was viewed as, almost a death sentence. And at least this is his argument. I'm sure there's probably a lot of people who might disagree with how he comes down on this, but that was one of his explanations for why you don't see some of these laws at the period. Obviously, there's all the reasons that you laid out there, as far as like things have changed quite a lot in how we apply criminal justice since that time, specifically in wildly expanding what a felon is. But and so he's trying to apply the standard faithfully, and then also offer his view of how you could move forward with potentially upholding these laws under the Bruin standard in a way that wasn't presented to him as an option it sounds like the government didn't do very much, didn't put a whole lot of effort into this case. At least that's the way the judge makes it sound. They didn't really offer him quite a lot of really any evidence of beyond surety laws, which are really quite different from gun bans, ownership bans or purchase bans, to support this idea that the law is historically grounded. So he kind of came up with his own explanation. I think you're going to see a lot of judges do that, and that's how things are going to work themselves out. But by the time it makes it to the Supreme Court, they're going to have a couple different options for and how these things should be interpreted under that text and tradition standard that Justice Thomas laid out in Bruin.